And then came the 1-2 punch knockout blows. Because of the way they answered the questions, they had accidentally disinherited each other. But it gets worse. Everything went to their children equally, outright at age 18. The generic language was glossed over when they read it, and they didn't think it was possible a computer program would leave an estate worth a few $1,000,000 to a few teenagers. How many teenagers do you know that could handle a $1,000,000 inheritance? I'm an estate planning attorney, and this is a story about how I saved 2 PhDs from accidentally disinheriting each other. They thought they were being clever by using an online will. Instead, they created a legal mess that could have cost their family everything. I'm going to tell you the true story of why their DIY will ended up in my shredder and how you can avoid making the same mistake. Every now and then, someone walks into my office proud. They drop a stack of papers on the conference room table. I did my will online. I saved a ton of money. Can you just give it a quick look? And way too often, after I review it, I have to give them the bad news. The document they spent hours creating, the one they're trusting to protect their family, isn't worth the paper it's printed on. In fact, sometimes it's much, much worse than having no plan at all. Today, I want to talk about why. Why do these documents, which come from a massive online industry, fail so often? The convenience is tempting. I get it. A few clicks, a credit card payment, and you feel like you've checked a huge item off your to-do list. But that feeling of security is often a dangerous illusion, and no one illustrates this better than my 2 PhD clients. A married couple came to see me. Both were brilliant with PhDs in highly technical fields. They were at the top of their game, detail-oriented, analytical, and incredibly sharp. They had done their homework, or so they thought. They used a popular online will platform, carefully answered the questions, and printed out 2 very official-looking documents. They signed them, witnessed them, and filed them away, feeling accomplished and like they were protecting each other and their children in case anything happened. Years later, a friend nagged them into getting a professional review, just in case. And that's how they ended up in my office. As I read through the wills with each section, I got that sinking feeling in my stomach. I had to explain that to these 2 brilliant people that their documents were a total disaster. The first and most obvious error? They had witnessed each other's wills and left the second witness spot blank. In many states, a relative and even an unrelated person who stands to inherit from a will cannot serve as a witness to that same will. By signing for each other and leaving the other witness spot blank, they had invalidated both of their documents from the get-go. A court would have just thrown them out. But it got worse. They had apparently answered the questions in ways they didn't intend because they didn't know any better. The online form never asked the right questions about what they actually wanted in a way that was easy to understand. As a result, the provisions named their friends and some distant relatives as the executors of their estates, not each other. So if one of them passed away, the surviving spouse would have had to deal with other people managing all the finances instead of being in control of it themselves. And then came the 1-2 punch knockout blows. Because of the way they answered the questions, they had accidentally disinherited each other. But it gets worse. Everything went to their children equally, outright at age 18. The generic language was glossed over when they read it, and they didn't think it was possible a computer program would leave an estate worth a few $1,000,000 to a few teenagers. How many teenagers do you know that could handle a $1,000,000 inheritance? These weren't careless people. They were experts in their fields. But being an expert in one thing does not make you an expert in estate law. This is the smart person problem I see all the time. The online platforms can't ask the nuanced, probing questions an actual attorney would. They give you a false sense of security, making you think that because you answered a dozen questions, you have a solid plan. My PhD clients understood complex science, but they didn't understand the specific legal requirements of our state, and the online templates certainly didn't save them. The story of the PhDs is dramatic, but it's not unusual. The errors in their documents are ones I see again and again and again. Let's break down the most common ways online wills blow up. First, you have what we call execution failures. That's just the legal term for not signing and witnessing the document correctly. It's the single easiest way to invalidate a will. The law is incredibly strict about this. State laws are all over the place. Some require 2 witnesses, some 3, some have specific rules about witnesses not being related to you. That online template that you downloaded doesn't know who was in the room with you when you get there and sign it, and it can't stop your son, who's a beneficiary, from acting as a witness if you went ahead and did that. A mistake that could get the will challenged in court. An incomplete signature, a missing date, or using an online notary not accepted by your local court can render the document useless. The second category of failures is even scarier. Substantive content problems. This is where the words in the will don't actually do what you think they do. This is what happened to the PhDs. Online wills are built on generic, one-size-fits-all templates, but your family isn't generic. Do you have a blended family? An online template might not provide your stepchildren correctly, or worse, accidentally disinherit your kids from a previous marriage. Do you have a child with special needs? A sudden inheritance from a basic will could disqualify them from essential government benefits. That requires a specialized legal tool called a special needs trust, or at least the appropriate language in your revocable living trust, something you won't get from a standard online form. And what about your house or retirement accounts? A will doesn't override the beneficiary designations on your 401k or life insurance. It also doesn't override how your property is titled. An online checklist doesn't integrate these things, creating conflicts between your documents that lead to confusion and expensive court fights for your family. Look, this is information. If it's making you rethink how you're protecting your family, do me a favor, subscribe to the channel. My whole goal here is to give you the information you need to make smart decisions and avoid these common, costly mistakes. I often hear the argument, well, isn't a flawed online will better than having no will at all? In my experience, the answer is often no. A bad will can be far, far worse than no will at all. Here's why. If you die without a will, your assets are distributed according to your state's intestacy laws. These are the default rules based on family relationships. It's not ideal, but it's clear, and it's a predictable process in probate court. A flawed or ambiguous do-it-yourself will, on the other hand, creates chaos. It's a roadmap to a legal battle for your family. One child might think the will is valid, another challenges it. This pits family members against each other, forcing them to hire lawyers and spend tens or even hundreds of thousands of dollars of their inheritance fighting in court. Probate attorneys don't like this information getting out because it makes people wonder whether probate really is a big deal or not. If this sounds different from what you were told, please leave a comment. And if you want more straight answers, like and subscribe. All the money you saved on the front end gets eaten up by legal fees on the back end. On top of that, a do-it-yourself will provides a false sense of security. You sign it, file it away, and believe you've protected your loved ones. You stop thinking about it, but you won't be there to see it fail. Your family will be the ones left to clean up the mess when the document is rejected by a court or torn apart by legal challenges. I've seen it happen. I've seen families destroyed by a fight over one ambiguous sentence in a will or a trust that was downloaded for $99. Think about it this way. You are betting your entire life's work on a piece of paper you bought for the price of a dinner out. And if you read the fine print on those websites, they all have the disclaimer. They all say, we're not a law firm. This is not legal advice. They take your money but accept zero liability if the document you sold fails and your family loses everything. So what happened to my PhD clients? We threw their online wills right into the shredder and started from scratch. We spent time talking through their goals, their family, their finances, talked about probate. I asked them questions they'd never thought about. What if you both pass away at the same time? Who will be the guardian for your minor children? How do you want them to inherit? All of it once at 18, or managed in a trust until they are older and more responsible. Spoiler alert, they didn't think 18 was an appropriate age of inheritance. We drafted a comprehensive trust plan that avoids probate tailored to them. It included provisions avoiding court, minimizing taxes, and protecting their assets. It was clear, legally sound, and most importantly, it actually did what they wanted it to do. The cost was more than the online template, but it brought them certainty and it brought them peace of mind. The reality is you don't know what you don't know. An online form can't give you legal advice or strategize for your unique situation. It can't replace the critical thinking of a professional who has seen hundreds of these plans play out in the real world. Your family's future is too important to leave to a template. That initial savings isn't worth the risk of future conflict, insane legal fees, and the possibility that your final wishes will be completely ignored. If this story resonated with you and you're ready to create a real plan that you can be confident will actually work for your family and suit their needs, I invite you to take the next step. Check out my free online course at freetrustcourse.com and then contact my office and let's go ahead and talk about your family, talk about your goals. What do you want to accomplish? And build a plan that provides you true peace of mind. Don't let a bargain shortcut end up costing your family everything.